latest out of the Illinois Supreme Court's case where they're hearing a challenge to Illinois' gun ban. You've got the Calkins attorney motioning for two Supreme Court justices to recuse themselves after they received large donations to their campaign funds by not just Governor J.B. Pritzker, but also Illinois House Speaker Emanuel Chris Welch. Good morning. It is Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. And this happened, of course, late Thursday and reported it out Friday and shared it with you. But the motion essentially is that Pritzker's campaign donations are grounds for the justices to recuse themselves in that challenge of Illinois' gun ban. So, some background here. You've got last year, before November 2022 elections, Governor J.B. Pritzker gave $500,000 to each of two then Supreme Court justice candidates, Mary O'Brien and Elizabeth Rochford. And those two candidates getting $500,000 from Pritzker's campaign fund, and then also $500,000 from the governor's trust fund for $1 million total each. But they also received six-figure donations from the Illinois House Speaker, Emanuel Chris Welch, both of which are lead defendants in the case that was brought by State Representative Dan Calkins out of Macon County that challenges Illinois' ban on 170-plus semi-automatic weapons, magazines over certain capacities, but also that gun registry that begins October 1st with the window closing January 1st. And if people don't register their firearms that are within the category of what legislators defined as assault weapons, then they could possibly face felony charges. There's a lot more to talk about the other parts of the law that are going to be implemented, including on April 10th, the issue of where you can have certain types of magazines and whether or not having those out in public could lead to a petty offense, a $1,000 fine. So we'll actually talk about that a lot more in the days ahead. But this issue of the recusal requests, let's go ahead and pour through this because, again, the governor giving $1 million to each Supreme Court justice candidates, Mary O'Brien and Elizabeth Rochford, and then they get elected. The governor signs the ban on assault weapons, and then you get the various cases that were filed, including the three cases from Attorney Thomas DeVore, and there's an update in that case we'll get to in a bit, but also the case out of Macon County where a judge issued a final judgment that the law is unconstitutional. That was appealed directly to the Illinois Supreme Court because the appellate court had already said the argument that the law violates equal protections is likely to succeed on its merits. So the appellate court already motioned that aspect in a different case, but the similar case out of Macon County that Calkins brought that's now in the Illinois Supreme Court. There's a lot of debate about which case is the best case. Is the DeVore case getting discovery, or is Calkins's case jumping the line to get in front of the Illinois Supreme Court? This is just the Illinois Supreme Court, not the federal court case, which in about 9 days, they'll actually hear that case in the Southern District of Illinois federal courts. We'll talk about that in the days ahead. But to the Illinois Supreme Court, let's take a look at this motion that was filed where you've got Calkins' attorney essentially saying that the justices should recuse themselves. And if you follow me on Twitter, you can see the story and actually download the filing. And it goes through in some detail about the need for these justices to recuse themselves, talking about individual contributions of $2.1 million in one instance. And again, highlighting how it wasn't just Governor Pritzker, but it was also House Speaker Emanuel Chris Welch with three-figure donations to those campaign funds. So it goes through the details, but it also highlights how, in particular, public perception of the independence is crucial in the judiciary, and we've talked about that in the past as well. But ultimately, going through and showing that various canons that judges are to follow, judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. And I think that that's important, the appearance, because it's really all about the appearance of impropriety. And if you've got these justices not only getting campaign contributions from top defendants in this case, that's going to breed a question of impartiality and even the appearance of impartiality. Continuing on, it wasn't just the donations that there were made. There were also concerns about the issue of where these justices stood on issues and what kind of support they got from certain campaigns to limit, the ability for individuals to have certain types of weapons. Now, if you recall, we asked Governor J.B. Pritzker about this in early March, about him to explain his $1 million donations, and here's what he said at a stop in Springfield.
$1 million that you gave to each Supreme Court justices, and should they recuse themselves in two important cases coming up, Safety Act, no cash bail, and also the gun ban.
I am sure this is something that the right wing is trying to stir up. I know you've written about it. The fact of the matter is I supported candidates who are running all across the board. If you're suggesting that the fact that I gave money to, let's say, the Democratic Party or to the committees that supported candidates means that everybody who received any money has to recuse themselves from anything to do with the state of Illinois, that's ridiculous. And I've certainly never asked anybody to vote a certain way or decide on a case a certain way. I would never do that. I never have. I never will. And these are independent judges, and they didn't go around and campaign on things, that they thought would win my support for them. I believe in them. I supported them like lots of other people did.
But it wasn't just the issue of the campaign contributions. You hear the governor there saying that these are independent justices, and the question isn't just, again, about the contributions. It's also about the support these justices received from certain groups that want to restrict firearms. And if you look at the Calkins motion for these justices to recuse themselves, the filing highlights how they received support through campaigns that are looking to limit the access to firearms. And in particular, if you pour through this document, again, the filing that was made late Thursday, it highlights how indeed their public perception is damaged here. At least that's the argument, and that there were some statements that were made from the GPAC, for instance, that had these justices listed as supporters of their position. Let me just find this here. And you get to some of the arguments, in particular of how, for instance, here we are. To earn gun safety endorsements, each candidate demonstrated strong support for banning assault weapons and large capacity magazines. Each endorsed candidate supported as a candidate the number one legislative priority when the General Assembly is called into session, banning assault weapons and large capacity magazines, including as endorsed candidates are the Justices Defendant Welch, Defendant Raoul, and Defendant Harmon. So that's, again, from GPAC, and even going further to spell out those concerns about what GPAC had to say, who they supported, and the Giffords PAC as well. Each candidate voiced their support, according to GPAC and Giffords PAC, for the what they called the top priority, banning assault weapons and large capacity magazines. So Governor J.B. Pritzker, again, saying these are independent justices, but the motion that Dan Calkins' attorney filed says that there's evidence that that's not the case and that these justices should recuse themselves. So what's the relief requested? Well, they say that for these and other reasons, plaintiffs respectfully request that Justice Rochford and O'Brien recuse herself on her own inquiry, or alternatively that the court disqualify the justices from any involvement in the consideration of issues presented in this appeal. But Governor J.B. Pritzker, again, a week after I asked him the question of him to explain his $1 million contributions to these two justices, another reporter asked him a question to further explain what he wanted to get out of these justices. And here's what Governor J.B. Pritzker had to say mid-March, just a couple of weeks ago.
My hope is that good people get elected to public office. That's why I think you would contribute, or anybody else in this room would contribute to somebody. I would also point out that unlike what some people are putting forward among the right wing, The truth of the matter is that my name is on these suits because I am an official representative of the state of Illinois. When I became governor, there were suits that were outstanding, and Rauner's name was removed from those suits, and my name was put on them. It had nothing to do with me specifically, just the fact that I happened to be governor at that time and this time. So, the conflicts that have been alleged are just, false. And I'm must say that I think people who run for judge do it for the right reasons, and I think that people who give to candidates for judge do it for the right reasons. And judges ultimately are required to make their independent decisions about the cases, and I think that's what judges that any of us support should do, and I hope will do.
So again, Governor J.B. Pritzker responding to further questions about whether this contribution he made damages the reputation of the court taking this challenge against Illinois' ban on certain types of weapons and magazines and a gun registry. What about Judge Rochford? During a debate last year, Mom at Arms, a blog that focuses a lot on Second Amendment issues, uncovered some video, and we'll share that with you coming up here next on WMA.
That's why I think you would contribute, or anybody else in this room would contribute to somebody. I would also point out that, unlike what some people are putting forward among the right wing, the truth of the matter is that my name is on these suits because I am an official representative of the state of Illinois. When I became governor, there were suits that were outstanding, and Rauner's name was removed from those suits, and my name was put on them. It had nothing to do with me specifically, just the fact that I happened to be governor at that time and this time. And
again, that's Governor J.B. Pritzker a couple of weeks ago responding to a question for him to explain what he was looking to get out of $1 million donation to each of two then Supreme Court justice candidates, when the governor is now a top defendant in the challenge against Illinois' gun ban. And he says there, he just happens to be the lead of the state, and there were lawsuits against the Rauner administration that they had to switch the names out. Well, people pointing out even on YouTube that the governor's the one that signed the ban on certain types of weapons. So it's a little bit of a different distinction there. But what about this idea of justices being able to ask themselves questions about implicit bias, about integrity of the court? And this was actually a question that was posed to justice candidates before the November election. This is from Mom at Arms, a blog that researches and reports about Second Amendment issues. And they highlight some of our reporting based off their reporting, doing deeper dives and asking the questions of the governor, getting to the recusal motion that was filed in the Illinois Supreme Court. But they also highlight this question about impropriety being raised at a recent forum. And here's some of what Elizabeth Rochford had to say about the question of implicit bias. And how justices should react if that is ever a question. Again, this is from a debate nearly a year ago.
Thank you. Judge Rochford.
So being in a courtroom and treating people fairly and impartially, there's some basic things that a judge is responsible to do, like be on time and be prepared and treat people respectfully. But one of the things that I have learned from actually sitting on the bench also, and through judicial education and through self-examination, is that a judge needs to be both aware of and acknowledging of his or her own, they call it implicit bias and they call it unconscious bias. And we all have it. And it's not something that is easily overcome. In fact, it really can't be overcome. We have to kind of train ourselves, teach ourselves to recognize it when we're doing it and find ways to address it and do better. But it's part of the fabric of who we are. And so as a sitting judge, there are things that you just unintentionally and unconsciously react to. It can be the way someone looks or the way they're behaving or the the accent they use or the language they speak. It can be such a great variety of things. And recognizing when your emotions run a little high or when you are quick to a judgment and taking the time to step off the bench or to reread a transcript for real facts as opposed to allowing yourself to be emotionally taken on that journey. Those are the kinds of things that experience on the bench help. And also education of judges is so critically important. I will say it's not that long ago that I didn't even really know what that meant. And it's through judicial education and it's through that awareness and self-examination that I have come to realize that yes, there are times that I jump to a conclusion and we can't. I am regularly reminded that even the members of the Illinois Supreme Court, when they are sitting in their courtroom in Springfield, on the back wall, there's a Latin phrase. It's audi alterum partem. That translates to hear the other side. And the reason I think that's so powerful is that the justices of the Illinois Supreme Court need to be constantly reminded at the back of the room to really hear the other side, to hear the entirety of a case on both sides before they jump to a conclusion. And so I think that's part of the journey, is first acknowledging that these things are real, they exist for all of us, and we're human beings, but we have a very important job to do. We're held to a higher standard. And also just finally, that sometimes also even the appearance of bias. So you may not be acting in a way that it really is biased, but the way that you operate in your courtroom can present the impression of bias to other people. And sometimes it's subtle, sometimes it's things you don't even think about. That's why you need to be constantly examining of yourself and the way that you run your courtroom, because you can give the impression to other people that it's a very clubby place, or, when they walk in, when somebody walks in, a litigant scared to death and feels that they are an outsider in a courtroom and that other people are at an advantage, whether they are or aren't, just that appearance of bias is a dangerous thing, and it undermines the credibility of our judicial system.
Again, that's then candidates for the Illinois Supreme Court, Elizabeth Rochford, answering questions about implicit bias nearly a year ago before the election, where she highlights, the understanding that even the appearance of bias can be detrimental. So we'll see what happens with this, with the motion that Dan Calkins' attorney made to ultimately have these two justices that received substantial contributions from Governor J.B. Pritzker and the Speaker of the House, two lead defendants in the case that's got the state having to defend itself against challenges that the gun ban violates equal protections. So when this is decided as to if these justices are going to recuse themselves or if the court's going to block them from taking part in the hearing, we shall see. But again, that's going to be heard mid-May in front of the Illinois Supreme Court. And that's separate and apart from the 4 consolidated cases in the Southern District that are going to be heard April 12th, so in less than 10 days here. So a lot of twists and turns here. We've even got more gun-related news coming up in Illinois, including the case of Thomas DeVore, his 3 cases, the Illinois Supreme Court getting a filing from the state asking for that to be held in abeyance, suspended essentially. So we'll review some of that later. Also, a case about FOID cards was recently decided. We'll delve into that too, but that's coming up later on here on WMAY. I'm Greg Bishop. Be sure to follow along. Bishop on Air on Twitter, Facebook, YouTube. Just search Bishop on Air, and we can connect that